Hi, good morning, Piyush. Good morning, Vaibhav. Good morning, everyone. Hi, Parishi, Shruti. So good to see so many of you here. Hi, Nana. Hi, Cruz. Hi, Shrishti, Balkrishna. We meet again. Tanisha, Aditya, Rishav, Arushi, Sai Prasad, Mansi, Prisha, Devansh, Harsh, Prajwal. Hi, everyone. Hi, Bhabi. Hi, Het. Hi, Sejal. All right, so good evening, good morning, everyone. Yes, the recordings will be available. सबसे पहले, whenever we meet, you ask whether the recordings of the session will be available or not. So yes, the recordings will be available on our YT channel. But before that, let me introduce you guys to the session and to Sir. So we are here to discuss the relevant events which have happened in the year 2021 and are extremely important for your common law admission test. We are joined by a superb professor, Mr. Rahul Mishra. He is an academia at heart and he has over 12 to 15 years of teaching experience. He has done his bachelor's, has done his master's in literature, and then he went on to do his master's in law from Nalsar University of Law. And he has been teaching at Nalsar and has relocated back to Delhi and has been a part of Alliance University since then. Today we will be discussing the most relevant events when it comes to law and when it comes to legal GK per se. And Sir will be taking ahead and going and talking about all the relevant events, including domains like health, space law, data protection, agricultural reforms, criminal law, so on and so forth. Yes, hi Shambhavi, hi Prajwal, hi Naman. Yes, it was important, Prajwal. Sedition is pretty important for that matter, but although, of course, CLAT has already made its question paper, so I'm pretty sure they're not going to ask you what has happened yesterday. But yes, it is pretty relevant, especially when it comes to ILIT and MHCT and so on and so forth. All right, so without any further ado, welcome to the show, sir. Hi, I hope you're doing well, sound and safe, sir.
Yes, sir. Yes, sir. By God's grace, things are going great guns. So that is what all I can say.
Right, sir. Right,
And
sir.
I'm happy to meet with the students because I am missing my physical classes actually. So I am teaching all my students through online mode only.
Right,
So I think it's a great opportunity for me to
right.
talk all these budding lawyers, I would say, because I hope they are all working with the whole might and main as far as all the entrance examinations are concerned.
Right.
So that is what I can say, sir. That is
Yes,
what.
sir. Yes, sir. So the floor is yours, sir. All the best. And
No worries. Yeah.
yes, sir. Yes, sir.
Okay, fine. So can I start the proceedings now?
Yes, sir. Sure, sir. Please go ahead.
Okay, fine. Okay, fine. So dear students, first of all, thank you very much for having given me this opportunity to talk to you people this fine morning. And I hope you all are staying safe and healthy at your homes. And I hope that you all are going to, create a space for yourself in this particular domain of law. So as far as today's I won't call it a class actually, because the people might have been having the habit of attending to the classes a day in day out. So I would just try to give a new name to this very class as interaction. This is going to be an interaction in between me and you guys, right? So accordingly, I am just trying to make you people aware of the important you can say legal what do you call that, issues concerned, challenges concerned, which the whole world has been facing for the past one and a half year. And accordingly, friends, I have divided this interaction into few parts, like I would just be giving you a very very deep insight about the legal issues, challenges concerned, right, which the humanity is facing at present. And accordingly, I guess today's interaction will definitely be very very fruitful for you people to write your all the entrance examinations to a great extent. And after that also, when you will become a part of any law school, you will have the basic understanding of all these issues to a great extent. So that is what I can bet you people. So if I have to start this interaction with you people, I would just be first of all taking you through the, this pandemic issue, because for the past 1.5 years we have been, going here and there, and the whole mankind has been eclipsed by this problem called COVID-19 pandemic. And friends, don't you think so that the international health laws, the national health laws have also been questioned? And if you see the country like India, we are yet to have a full-fledged national health, you can say, act to be put in place, because we have had diversified, you can say, acts in place, which are basically catering, to the needs of availability, accessibility, affordability of the important medicines, including vaccines. And you must have seen that till date, I think not more than 40 crores of the people in our country have been vaccinated. So that simply means that, the health infrastructure needs to be revamped, actually, so far as our country is concerned. And we have had various national health plans for that matter in place. And mind you, India is also a party to various internationally acclaimed institutions, like India is party to WTO, World Trade Organization. India is party to United Nations. India is party to WHO. And that simply means that India has taken up some obligations, being part of those internationally acclaimed institutions. And accordingly, the availability, the affordability, and you can say, the accessibility to all those important essential medicines, including vaccination, must be made available to the poorest of the poor people of any society. And mind you, friends, if I say so, I am considering the most, the developing nations, including least transition economics. And for that matter, you must have seen in the last year, so much of debate had happened at the WTO headquarters also. And accordingly, India had also raised his concerns to go for the IPR waiver. Now, IPR means intellectual property right waiver. That waiver will basically make it convenient for the, poorest nation to import all those important vaccines or medicines at an affordable cost, and which could be made available to the nationals of those nations. And accordingly, millions of lives could be saved. And so this is a great problem, actually. Now, friends, when it comes to the TRIPS agreement, you people must be knowing, trade-related intellectual property rights agreement. That is very, very important agreement. And that agreement has to be read with the Doha Declaration. Now, when it comes to the composite reading of these two important agreements, in the last year also, this was seen that the public health, maneuvers or the public health scenario, has to be properly taken care of, right, at this juncture when the pandemic has engulfed the whole world. And therefore, there has to be a proper, you can say, national health program or missions which must be put in place accordingly. In our country, if you see, we do not have national legislation on this, you can say, aspect. Like if you see the South African scenario, if you see the Canadian scenario, if you see the US scenario, they have a full-fledged national health act which takes care of all these issues concerned, and especially the poor people, that how the medicines concerned or the vaccines concerned, for all the, you can say, what do you call that, life-threatening diseases could be made available to those people, because everybody cannot afford to, go to the private hospitals. Everybody cannot go to, afford to go to, United States for the cancer treatment, for the tuberculosis treatment, you can say, for the pneumonia treatment itself. So therefore, there is a long debate basically which has been happening till date. And I think last year also, when the pandemic came, at that point of time, all these loopholes were revisited by most of the academics in the world itself, especially the academics which were representing the developing nations. And therefore, friends, so far as this availability and accessibility of all these essential medicines is concerned, I think the power basically is coming from, UDHR 1948 declaration, in, along with some other important protocols which were basically put in place, and accordingly right to health was made available to every person, right, who was representing the international community. Then after 1945 also, you must have seen all these things were there. Today also, if you see the availability of this right to you can say health declaration or right to health scenario was, thought. At the same time, if you see the Indian scenario, again, you will have to go through the Article 21 of the Indian Constitution. If you go through the Article 21 of the Indian Constitution, you are able to understand, because that article basically tells you people something about, you see, right to live with dignity, right to live in the congenial, you can say, environment. Understood? So the Supreme Court has taken this initiative from time to time for the past 15 years. The Supreme Court has given you wonderful judgments, and accordingly, this right to health has been envisaged as the very, very part and parcel of Article 21. And therefore, it is for the state basically to create those conditionalities, to create that sort of ambience, which could enable every person, especially the poorest of the poor person, right, right, to get access to all these essential medicines. When it comes to the essential medicines, friends, you must have seen, if you go through the WHO, World Health Organization's list of essential medicines, you are able to understand that what are those life-threatening diseases. For example, heart attack is the, heart problem is there. Cancer problem is still there. HIV/AIDS is also still there, Then pandemic-like situations are also being envisaged these days, And for these things, the world is not prepared. You must have seen that during this pandemic, lot many people had been killed actually, the worldwide, because the world was not prepared. So as far as the law point is concerned, I would simply tell you that the world has to revisit all the internationally acclaimed protocols. And so far as developing nations are concerned, their requirements must be zeroed in known by those nations, developed nations. For example, the internationally acclaimed pharmaceutical companies could also be provided some incentives, because they will get the patents with respect to the discoveries they will make. And according to TRIPS agreement, and according to Indian Patent Law 1970, definitely once the patented medicine is there, they can try to make money out of it. But at the same time, you have the obligation under various other internationally acclaimed protocols to take care of the public health. So therefore, this public health has not to be compromised at the cost of any sort of incentive which all these pharmaceutical companies are going to make. And accordingly, friends, all these things are to be resettled actually. And in the last year, you must have seen so much of debate was happening, and the Asian African nations have basically raised this very voice that as far as IPR protocols are concerned, they must be put in such a manner that all these states could get that best of medicines, best of, you can say, medical products, best of health treatment at a given point of time in their states also. So these are basically the anomalies which you people are finding even today also. And this pandemic has made it possible to revisit all these, foregoing chapters, which we had never considered actually. Things are still on the paper. So here, a lot of work is yet to be done as far as this particular, you can say, domain is concerned. Then the second important domain is, friends, the plight into this space. Now you must have seen, if you have been through, the you can say newspapers, then you must have seen that the private players from countries like US have also gone into this space. So you have 5 important treaties when it comes to the space law. You have Moon Treaty in place, you have Registration Treaty in place, you have Outer Space Treaty in place, right? You have Astronaut Protocol in place, right? So you have Registration Treaty in place. So most of the nations are party to these treaties so far as international framework is concerned. Now, where does India lie out here? What India should do? Because the developed nations have started sending their private persons into this space through their privately owned spacecrafts. But when it comes to the developing nations, you must have seen in our country, even in the last year also, there was a bit of space policy which was basically introduced, and Dr. Sivan, who is heading the ISRO, he basically made it possible that there could also be the presence of private person with respect to the, maneuvers which the ISRO is taking up with regard to the space to be explored. So what does it mean? It simply means that the private players like you, lawyers like you, scientists like you, or maybe some of you people might be scientists and you are having your own lab. So you guys can also contribute to the overall development of that particular spacecraft, which is to be sent into the space by Indian Space Research Organization. So that is a wonderful thing which has happened. last year. At the same time, friends, there is also a lacuna out here. The lacuna is we do not have that space legislation in place. Now, the question concerned is why we should have space legislation. Dear students, in order to properly take care of all these maneuvers into this space, there has to be a nationally acclaimed and accepted legislation, because India has been a party to most of the internationally acclaimed space conventions. So you must have studied in your constitutional law classes, in your coaching centers, that when the international law has been accepted by a particular domestic state, then it has to be implemented accordingly. And for that matter, there has to be a presence of a legislation concerned. It has to be tabled in both houses of the parliament, and accordingly there has to be a proper act to be put in place, and according to that you will put forward all those maneuvers concerned. For example, there may be a catastrophe, there may be a problem, there may be a person who may ditch the program, right? There may be a kind of issues concerned with respect to the financing and all, or when it comes to the a criminal aspect of all these things, because what is the penalty if somebody does wrong to that particular mission? What is the penalty? What is the ultimate authority from the government side? Who is going to fund, right, the particular space maneuvers actually? So all these are the questions. And mind you, I would also encourage you to go through the space law policy 2017. That is being revisited every year, friends. In 18 also it was revisited, in 1920 also it was revisited, but it is yet to take a proper shape of law. And unless it takes a proper shape of law, I do simply believe that merely on the basis of some sort of policies, the Indian space research program cannot see the proper light of the day, the way it has seen in the developed nations. Like you see, Europe has a developed space agency in place. Japan has a developed space agency in place. US has also a developed agency in place. And accordingly, they have all these sorts of important legislations according to which they are basically going forward into this space itself. Right. So this is another important challenge as well as legal happening. And here you guys can definitely see the advancements which are basically being made by our country into this space itself. They are mind-boggling. But at the same time, so far as law point is concerned, there has to be a proper justification that has to be given, right? According to the experts which were given last year, you can say by Dr. Sivan, right? That how are you going to legally, control all these maneuvers? Because law must protect, that sort of invention or that sort of discovery. That is very, very important point, dear friends. Then the next important scenario, a legal scenario, is pertaining to data protection. Now you people must be knowing, most of us, I think, are on the social media platform day in, day out, isn't it? You guys must be, checking your first, WhatsApp this thing or Facebook or something. But have you guys ever noticed that somebody's there in the dark who is basically having a vigil on what you guys are doing, though you have not permitted, right? Though the terms and conditions are there, right? But you people do not know, because you are kids actually. You do not, you just only know that how to operate this particular app, how to operate this particular social media platform. So the thing is, you have the Information Technology Act in place, and accordingly you must have noticed there are so many amendments which have been done to that act in order to take care of this privacy, which is your now fundamental right. Because if you see the Puttu Swami judgment, mind you, you guys must have been through the Puttu Swami judgment. So in that Puttu Swami judgment, this was made clear that right to privacy is the very, very important part and parcel of Article 21. And accordingly, in our country, Justice Sri Krishna Committee had submitted that particular bill, right? A data protection bill, 2019. And I think last year it was put before the Joint Parliamentary Committee, and this bill was properly understood, and some loopholes were basically there. And loopholes have been categorized, and accordingly, still this bill is basically in the pipeline. It is yet to become law. Understood? So this is another important event. And now you must have seen the Twitter problem which was being faced in our country, and you must have seen the kind of responses, or the kind of, what do you call that, lackluster responses which were given by that particular regime to our country's law itself. Because for our country, our national integrity is supreme. The national security is supreme. So if there is something which is imposing threat to our national integrity or sovereignty, definitely can be questioned by our nationally acclaimed law agencies. And for that matter, you must have seen that the Facebook, Indian representative was called, by our state, and likewise, some other presentations were made by WhatsApp people also, and all these things were done because there was a kind of anticipation, from the government of Indian side that some sort of, what do you call that? Stealing is basically being done of that data, which we are basically sharing on these platforms. Then OTT platform has also come into big, friends. And mind you, I am really very, 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 deeply, hurt having shared this thought with you people that there is no proper, you can say, articulation, which is basically done, to the programs being broadcasted through these OTT platforms. For example, if you see Article 19 gives you the free speech expression. But Article 19B is all 19.2 is also there. 19.2 simply says you can speak, you can gather, you can be a part of any particular union, but you cannot create any ruckus. You cannot create any trouble to others who are associated with you. Understood? So that point is very, very important. That is our supreme law. But if you see some of the programs which are being broadcasted on OTT platform like Amazon and all, you will definitely be very sad, the kind of language which is being used, the kind of responses which are being given. So I think there has to be a very strong regulatory mechanism in our country for that matter, which must be kept in place, and accordingly, the certificates concerned must be provided to all these programs. And mind you, 2 months back, I believe that Mr. Prakash Javadekar, along with Mr. Ravi Shankar, they both had sat together and had a press conference. And they had basically come out with this particular policy in place that is how to regulate all these platforms to a great extent, because for ourselves, the morality part will also be equally important. The integrity, you must have known these things, no? Public integrity, public interest, and public morality. These three things are quite important. Whichever law you guys study, you will find out the usefulness of these three, what do you call that, important terms. And accordingly, whichever law is basically being made available to you people, this particular, you can say, aspect cannot be seconded, right? It has to be properly checked. So a lot of debate basically went on this particular issue last year as well. And therefore, this data protection bill, which is still on the anvil and on the upgrade, I think is very, very important to be put forward. And mind you, before this bill was basically crafted or drafted by Justice Sri Krishna Committee, the European Union guidelines had been considered to a great extent. You must have known, right? The European Union guidelines on data privacy, right, are very, very authentic guidelines, and I hope you must have been taught those guidelines, and accordingly they are basically taking care of the global picture of this data privacy protection. That if there is a third party which does some wrong with the second party data, then the European Union has the power to take care of that person and accordingly punish that person. So that is what, and accordingly this Sri Krishna Committee has basically come forward with all these things. But it is yet to see that in 2021 whether this bill takes the shape of full-fledged law or not. Then friends, you have next important segment called agricultural reform. So I hope you all people are basically, you can say, studying all these legal connotations pertaining to these agricultural reforms, and you must have seen all those laws had basically come into being. But there was some section in our society which was not happy with those laws. But mind you, I have been through these laws, and I hope the law part of this, you can say, important, you can say, happening must have been gone through by you people, and you must have found that there is also a concept of, you can say, ownership rights which will remain there with the person concerned who has got that agricultural land, and there is also a participation of the private entity in such a manner that there is going to be a feasibility to be done to the selling of that particular crop at a decent price. And for that matter, MSP will come into picture, and a maximum retail price that will come into picture. So this thing has also been taken care of. I am just trying to give you the legal perspective, which was understood by the academia, by the judiciary itself, and by the you can say makers of the law itself. So that point I am trying to, you can put into your consideration. And accordingly, friends, lot many other comments were also there as to whether this law is going to help, the peasant class to a great extent. So there was also a committee which was made, by the Supreme Court concerned, and accordingly things went further. But so many protests also did happen. So this is again a new sort of, you can say, what do you call that? A win-win situation which has been created, by our state itself. And accordingly, for the past, I think 15 years, such reforms were to be done, but nobody, took this initiative to go for these reforms. So as far as law point is concerned, that is surely going to be beneficial to the peasant class, because in our country, you must have seen that you have fistful of states wherein some issues were basically there. No other state has basically, come up, with this kind of uproaring as to whether these laws should be turned back by the government of India, or should these laws be staying there, right? Then, friends, the another important event which came into being was trade restrictions. You must have seen that the kind of irresponsiveness which was shown by our neighbor, that is China, at the border itself, right? And with regard to the national security, national sovereignty also, right? There was a foolproof information which was basically provided, to our state, you can say, by some of the officials, that the data basically concerned is leaked out, is being misused, through some of the apps actually, which had been launched by China. And I think we had been using those apps, right? Like TikTok, you can say, WeChat, then Hello, then Share It, you can say, Club Fact itself. So these are some of the apps, and accordingly, the government of India took, you can say, the proactive step, thereby banning most of these apps, which had causal connection with Chinese regime, right? And so much so, when it comes to the foreign investment, you guys must have noticed one important point, that when it comes to the opportunistic takeaways, because when pandemic came, you had some small businesses in place, middle businesses in place, which could not sustain that problem. You must have seen so many layoffs were done. So many people lost their jobs. Migrant was also one of the problems. And accordingly, the government had to reshuffle, their laws which were there in place. Because when it comes to the foreign investment, so some rider came into being. What was that rider? That rider simply said that whosoever is interested to take over, any sort of firm in our country, right? In our country has to take prior approval from the government of India, right? Moreover, this, according to this rider, the person must be situated in the neighboring nations, of India, you can say, like China, Bangladesh, Pakistan, for that matter. So this was a very, very strict clause which came into being, right? That unless the government of India, approves this sort of, you can say, takeover or amalgamation, it may not be done, for that matter, dear students, right? So this was another important law point which I think I should share with you. Then when it comes to the foreign direct investment, you must have seen that during last 1.5 years, in case of defense, it has increased up from 49% to 74%, right? As far as defense is concerned, right? So this is how this change was done. Then in case of retail trading, 100% FDI was made possible. In case of digital media, 26% of FDI was basically made possible with the prior approval from the, concerned department of the government, right? Then, friends, you must have seen also the Companies Amendment Act 2020. Now, the Companies Amendment Act also has decriminalized some offenses under this particular act, right? For example, I can just give you some example, like, the under this Company Amendment Act 2020, the some provisions have been removed, right? In terms of the criminal punishments, or those criminal punishments, have been replaced with civil punishments. And when it comes to civil punishments, maybe the compensation could be the ground, or the compensation may have to be given, but the confinement may not be possible. The imprisonment may not be possible, and you may have to check this winding up proceedings, for that matter. You may have to check also, the correcting measures to be done to the registers of security holders and redemption of debentures. And accordingly, you will see that all these changes were basically brought into our consideration. Understood? If you see the Companies Amendment Act, you can say a 2020. So this is another important change which has been done. Moreover, the corporate social responsibility, right, and the corporate governance are two important pillars within the whole company law. So last year also you must have seen, right, the government has basically released so much of money in order to save the small scale industries, the middle scale industries, lest they should perish. So much of lakhs of rupees, crores of rupees were basically given for their revival actually. So accordingly, or you can say the sick industries, we are given some sort of boost, moral boost, so that they could withstand this problem being faced by the whole world in terms of COVID-19, you can say pandemic, right? So this was another important segment, friends, which I thought I should bring into your consideration. Then, friends, we have had so many challenges in terms of legal implications, in terms of laws which are there in place for so long. We have had challenges in terms of so many reforms which are yet to be done. For example, if you can see the judiciary, so you must have been taught that collegium sort of thing, that how the judges for the higher judiciary are going to be chosen. So that has still been a problem, that what should be the best criteria in order to choose the judges concerned for the higher judiciary. And for that matter, I believe, right, for the past 5 years, there has been a constant debate which has been going on, that what should be the best criteria, how the best regulation should be put in place, according to which the judges concerned in transparent manner should be chosen or selected, for the various posts which are lying vacant. And mind you, crores of cases are still pending in high courts of most of the states and in Supreme Court also. So you can well imagine that we are, I think, being pressurized by the society to create that sort of additional sort of courts at the civil level, at the criminal level, also at the higher judiciary level, and accordingly, the judges concerned should also be appointed to those posts. Moreover, friends, you must have seen that there has also been a long-standing debate which has been going on as to whether we should have an Indian judicial exam to be put in place or not. Understood? So even at present, we don't have that exam. I think the people are chosen by the respected, you can say, commissions of the states concerned for the posts of civil judge junior division, or you can say magistrate junior division. So I think this is again a very, very important focal point, which was touched upon last year also by the law ministry concerned, right? But again, the proper decisive step is yet to be taken as to how to, you can say, reduce the workload, which the judiciary is already having. At the same time, corruption is also another problem. You must have seen for the past couple of years in some of the states that how the cases are basically being dealt with, how the judgments are basically being dealt with, understood, and how the corruption has eclipsed this particular judicial system of our country. And for that matter, this is also anticipated that some very hardcore step needs to be taken, right, as a part of challenge which could be properly addressed and which could be properly put in place. And therefore, ombudsman will play a very important role here. Lokayukta, you can say that. You have the ombudsman in place, and most of the officers are coming under its radar itself for that matter. Kejriwal's movement you must have seen. So accordingly, can we have that sort of scenario out here? That is again $1 million question, right? So a lot of debate did happen last year also, and this year the step concerned is yet to be taken. Then, friends, you must have also seen, the promotion of renewable energy. Renewable energy. For example, Tesla has come into our country. So Tesla simply means that now we have to take all those environmental concerns on a very serious note. You must have seen the metabolism of the atmosphere, how it has been affected by the negative impact of all the transportation which is happening, especially in the developing nations or in the least developed, you can say, nations. And accordingly, now the time has come that there has to be a replacement, right, of all that sort of energy. For example, if you have access to the electric vehicles, right, if you're going towards electric vehicles from the petrol fueled vehicles, I think that will definitely be an add-on to save the Mother Earth for that matter. But again, there has to be a policy concern, because you have been a party to, you can say, internationally acclaimed environmental protection programs. You have been a party to Kyoto Protocol. You have been a party to other important dimensions of this, you can say, what do you call that, important, environmental programs. So accordingly, so far as India is concerned, in spite of the fact that we have had a properly developed environmental ministry, but I think still steps are yet to be taken. And accordingly, maybe Tesla can set a wonderful example in our country when it comes to the production of the electrical, vehicles for that matter, which will definitely reduce pollution to a great extent. So this was another important debatable issue, right, which was being focused by the current government in our country. And accordingly, we are yet to see as to whether we are in position to get along with the internationally acclaimed legal system for that matter, which will help us reduce or minimize carbon emissions to a great extent. So this is another important challenge, which we must address at present. Then next important scenario is pertaining to the technology use or abuse. You must have seen a few days back, like, some drones we are seen to have come from our neighboring nations, and they had entered, the Kashmir side, and some explosive was found or something was found. And I think some issues happened out there. Now, what does this mean? We have the drone technology in place. We have the guidelines also, how to take care of, these drones and how to make use of these drones. But we must also have a very, very stringent policy with regard to the attacks being done to our national sovereignty, by other nations for that matter. And I think there has to be an internationally acclaimed effort which must be put in place for that matter. And UN can take a lead out here, United Nations for that matter. You must have seen the kind of a threat which was imposed, because you have the zone, you have Indian zone in place, and it can definitely not be threatened by anybody else. For example, in aviation law, you must have studied. In space law maneuvers also, you must have studied. You have zones in place. So my zone is basically meant for me. If somebody is coming from outside, he has to take a prior approval from my side that whether I can enter your air zone or not. You must have seen that, right? And accordingly, when it comes to the presence of drones in this way in our country, this is really going to be a great threat. And therefore, there has to be a legal framework or decisive legal framework which has to be put in place in terms of legislation. You can say you have policy in place. We have the policies in place out here. But the question is, we have to take care of all these threats, and accordingly, there could be a revival which could be done to all those pertaining laws which are there in place in our country, right? So that could be done. Then, friends, another important concerned issue is child trafficking, right? For example, you have studied adoption laws in your country, you have adoption laws, you have Juvenile Justice Act in place, you have Hindu Adoption Act in place. Then you have all these segments out there that the foreign parent can also adopt Indian, you can say, kid, or Indian kid can also adopt foreign parent, right? Or intrastate adoption can also happen. But friends, you will be astonished to know that under the garb of this adoption regime, there has been a maltreatment which is being given to the kids itself, who are being given by the antisocial element to, in the hands of wrong parents. And this is how this trafficking business is basically flourishing. And I may make a mention of a very, very important case which was decided by Supreme Court, Lakshmikant Pandey versus Union of India. If you go through that case, Supreme Court has come out with very, very important guidelines. That's how the international adoptions, national adoption just should take place, and how the agencies concerned should carry on this particular work. But in spite of those guidelines, in spite of the hard-earned effort being put in place by Ministry of Child Welfare, still these things are going on. So I think last year also, when this pandemic happened, you must have seen many small kids got displaced who had lost their parents. Understood? Who had lost their parents and who were basically belonging to the very, very lower strata in our country. Now, what may have happened to those kids? Where those kids might have been gone. So this report was also, I think made available, and some news was also being broadcasted by some of the channels that, those kids are basically being manhandled by some of the antisocial elements who are also there in the society. So I believe that whatever adoption laws we people have as of now, whatever adoption laws, whatever internationally acclaimed adoption laws or conventions we have ratified, I think we will definitely have to take care of this important segment. And accordingly, we will have to provide more and more impetus, with regard to the protection of all these kids who may not be having parents, or who are belonging to the poor people, who are belonging to the poor section, whose parents are poor. But unless and until there is a proper discovery of facts which is made with respect to the prospective parent, I think that kid should not be given under adoption. And moreover, there has to be a proper agency or mechanism or program that has to be put in a very robust manner. You have agencies in place. You have the agencies which are working at the national level, at the district level, at the state level. But I think those efforts are not enough. And had these efforts been enough, such problems would not have erupted like a volcano. So therefore, this is high time that the existing laws needs to be repaired, needs to be revamped, needs to be refined, and wherein there must be a proper law regime which must be put in place. And accordingly, during the pandemic situations, epidemic situations, the kids who have become orphans actually should be provided a proper home, right, for their overall development, because Article 21 of the Constitution is equally applicable to them also. There is nothing written in the Article 21 that the person who has lost his parents does not have any fundamental right. That is not written for everybody. Understood? Article 21, so far as Indian citizens are concerned, it will be equally applicable. So accordingly, you have the policies, legislations concerned which have been put in place. So therefore, I think the state has to look into this particular matter also. And this is again a very, very debatable topic you guys can take care of. And accordingly, you can analyze it, and you guys can take the discussions further as well. Then, dear students, the next important happening is regarding a National Education Policy 2020. Have you been through this education policy? This is a very, very good, important document. I will just try to give you some of the important, you can say, what do you call that, maneuvers, which the government of India has taken up under this very policy. First of all, there is also a relevance of vocational courses which have been considered, right, to a great extent. Then the global scenario with respect to the education to be provided to the kids at the primary level, at the secondary level, at the tertiary level, at the college level, you can say, at the university level, has been considered. And for example, if I ask you nowadays, you people definitely would like to be a product which could be acceptable, which could be, what do you call that, commendable in the whole world. It is not the case that you are studying some sort of course in our country and you are not able to go to United States. And that thing should not happen. That is how the globalization has basically given you that sort of understanding of all these courses. Understood? And accordingly, this new education policy, which was rolled out and I think has come into being, has made it available, all these things. For example, what do you mean by skill-based education, right? What do you mean by, what do you call that, value-based education, right? Then you must also be in position to utilize that part of your education which you are getting in the classroom. Or in another way, what we can say is that you must also know the utility value of that particular course which you guys are going to study. For example, if you have taken up a drone technology as a specialization, right, at your UG level, then you people must know also that whether your interest, right, or your compassion or passion is matching with that particular study, because there may be so many aspects to study drone technology, to study computer science, to study law. So there has to be a matching of all these things. And accordingly, there is also a mention of, different sorts of diversified languages, which must also be taught to the students concerned. You must have seen some of the institutions in our country which are also giving you that sort of platform wherein you can study the languages of other countries as well. For example, the Spanish is there, English is fine, but Spanish is there, then Chinese is there, Japanese is there, you can say French is there. So these are basically the language, because in Germany, for example, in France, for example, in Russia, for example, if you go for some, sojourn or any sort of, educational studies or something, you must know their language. That is very, very important condition precedent. So some of the institutions are also focusing more on imparting this sort of language understanding. And so in that sense, you can say the holistic developmental scenario with regard to the kid has been taken care of when it comes to the new education policy, friends. So I think it has definitely eclipsed the already in existence, you can say, policies which we had already. And I think now, but we will have to see that how far this policy is going to help you people realize your dreams in full potential. So that, I think, will basically be the thing which will have to be looked into. I think the results are yet to come. Understood? Then, friends, the next important scenario was pertaining to online education. Online education, you must have seen, because as you see, with the coming of this pandemic into the world, the world was not prepared. So when it comes to regulate this particular issue, because this pandemic gave rise to so many anomalies when it comes to our lifestyle, when it comes to our eating habits, when it comes to our study habits. And mind you, when it comes to the kids concerned, there have been some negative impacts also which we are found to be there in the society. For example, if you look at the lower strata, which is hardly managing to send their wards to the school, can that strata provide mobile phone or laptop or tab to their kids? Certainly not. Then what may be the facilities which may be provided to those kids also, so that they could study properly? So that was one important issue which is still there, in some parts of our country. So again, when it comes to the legislation maneuvers, when it comes to the rules maneuvers, when it comes to the regulation maneuvers, there has to be something which must take care of all the kids together. And so unless you have this technological support which is made available to you people, to your ward, he or she is definitely plucked. He or she is basically gone. His future is basically gone. So he or she is not born with the silver spoon in his mouth. So I think here also the state has to show much concern that how this equality, because Article 14 talks about equality before law, equal protections of law, and you have the education to be made available to all people without any caste, creed, culture, and all. Understood? So this was another important problem or law problem, you can say, because unless you have the decisive regulation in place, you are not in position, you can say, to go ahead with, all these facilities which you guys can provide, to the students concerned. He or she may be studying, in some village of Sikkim. He or she may be studying in Shimla, Himachal Pradesh, right? But he is basically not having that accessibility to the internet thing or something like that. Then how can he carry on his dreams? How can he carry on with his classes? So again, there has to be a sort of important, I think, this is what I personally suppose and believe as an academic, that some sort of regulation must also be brought into the consideration of all, the, what do you call that, the student community, that some sort of decisive steps are going to be taken by the states itself, so that all those kids could get or catch hold of all these facilities. Then, friends, the next important scenario is about Atmanirbhar Bharat. Like, if you see the impact of pandemic 2020 on the developing nations like India, it was mind-boggling actually, because you must have seen lot many people, you can say, were also killed. They died actually. Then people lost their jobs. The industries could not sustain this, basically a problem. Then it was also problematic, a scene for all of us to get as many medicines as possible from the outer world also, right? To take care of our own people, because that time experimentation was on. We had not come through the our own vaccines actually, so it was basically on. So that's why there was a complete lockdown in our country. So have you been through that rough drought actually? So that simply means that Atmanirbhar Bharat, I think, was the wake up call which was given by our prime minister to everybody, that let us try to develop all this stuff in our country on our own. And accordingly, I am happy to tell you that more than 1.10 lakh crores of rupees were basically given to micro, small, medium enterprises, which got so much of effect because of this pandemic sort of scenario or issue. And accordingly, things were very worse actually. In addition to that, you must have seen, once the vaccination came into being, accordingly, the government is also thinking to provide license to other pharmaceutical, you can say, people, so that it could be made, on a continuous basis, and more people could be vaccinated, every day for that matter. So I think, friends, I am done out here. I hope I have done justice to my important events, along with the explanations and analysis which I have provided to you people in a very analytical manner. And guys, if you have any question, you can just let me know that question. I will definitely be answering that question to you guys. So thank you so much for your patient hearing. Thank you so much. God bless you all. Stay healthy and stay blessed. Over to Aditya Shekharji.
Hi, sir. That was a wonderful session.
Thank you.
Yes, sir. Yes, sir.
I hope I have been able to reach to the minds of your students, sir. I hope so.
Yes, yes. In fact, the entire objective of the series is to showcase how law school teaches.
Yes.
So that way is the series is based on that, wherein deep and intricate information about a particular topic is given.
I hope I have done justice, sir.
Yeah, yes, sir. Yes, of course, sir. Goes without saying. So, guys, any of you, if you want to ask anything,
No worries. Yes.
please go ahead
Nice.
and put it out. You can either ask on the chat window, or you can also put your questions on the Q&A tab. Anything with respect to your current syllabus. Sir, Vaibhav is asking details about the Uniform Civil Court as Delhi High Court recently.
Yes. Okay. I will speak. Okay. See, dear student, as far as Uniform Civil Code is concerned, discussions are going on. For the past 2 decades, discussions have started. But I have just also made a mention that there has to be in order to combine all the opinions all together at the same point of time will be a Herculean task. So this is definitely going to happen one day, but I think overnight it may not happen. For example, when it comes to the marriage laws, divorce laws, when it comes to the adoption laws, when it comes to the custody laws, you see, you have a community, you just stay in the community, and every community has its own whims and fancies, its own customs. You must have realized that, right? And accordingly, all of a sudden, overnight, you cannot club all those customs together. But I think this is just a call which has been given. Let us see that how far we are able to successful as a society to accept this Uniform Civil Code with respect to all these measures which we have been living with for since ages. Thank you.
Right, sir. So another question which Sagar asks is merely criticizing the judgment of a Supreme Court or High Court can bring contempt of court.
Pardon? Can you repeat the question?
He's asking whether if somebody criticizes the judgment of Supreme Court or High Court, can that amount to contempt of court?
See, no. See, the thing is, like when you will join the law school, you will also be given some case comments. Right. So case comments simply means you are expressing your comments. For example, I may be going with the ratio because when you see the judgment, it has 2 components, ratio and obiter dicta. Ratio decidendi and obiter dicta. So ratio means the actual law which the court has made, right? Ratio. And obiter means the opinions, because there are sometimes you must have seen constitutional benches. Let us say 5 people are sitting and 4 people say this should become law. One say this may not be law. So the one who is negating that law should also be understood by you people. You can go with this opinion. Like Justice Y.V. Chandrachud, you must have seen his opinions in most of the judgments. He has been sitting in constitutional benches for triple talaq case, you must have seen. Ayodhya judgment, you must have seen. I would encourage you people to go through these judgments itself. Privacy, Puttu Swami judgment, you should go through. Understood? Then you can say all the judgments are very important. So it may not be amounting to contempt unless and until you are obeying Article 92 of the Constitution, 19 within bracket 2. You just come out with your own, for example, we academics, we do the same thing, but we are all writing down as a footnote that this has nothing to do with others' opinions or something. This is just my opinion. I would like to go with the minority opinion. I am not happy with the majority opinion, but at the same time, you have to evidence that opinion of yours, right? For example, if you're not happy with the opinion which the court has given and you want court something else to be done, then you should also have the evidence. Law means evidence. Support. You must support your argument. And so that thing should be done by you. So it is not a problem. It cannot be a contempt of court. Not at all.
Right, sir. And the final question for the day. So Shambhavi asks, sir, please explain the judgment on SEBC from Supreme Court and also Indra Sawhney case. Sir, I would ask you to just go ahead and explain Indra Sawhney judgment in brief, maybe in a couple of minutes. That will.
When it comes to all these judgments, whether it is Indira Sawhney judgment or DK Basu versus State of West Bengal, Vishakha versus State of Rajasthan, all these are the judgments are very, very important for you people. Triple talaq judgment, you can say, right? Then you have this one. Puttu Swami judgment is also very, very important. Keshwananda Bharti's judgment is also very, very important. So dear students, see, law is all about opinion. I will give you a holistic picture. So far as these judgments are concerned, you find the opinions being made by the judges concerned, keeping in view the arguments which are being led before the court by both the parties. Sometimes one party is state, sometimes one party is the common man. Understood? And you must have seen sometimes it was said also that preamble is not the basic structure. Sometimes it is said preamble is the basic structure of the Indian Constitution, cannot be tampered with. You have been through all these judgments, no? Right? So that is what. Then you have Golaknath case also. So the thing is, there is also one important stuff which you people will understand with respect to the constitutional law. Progressive development of constitutional law. Progressive development. Law has to change because the values in the society are also getting changed. For example, today you are talking about data privacy. 50 years back, our forefathers had never thought that data privacy will also be a part and parcel of Article 21. Today you are taking care of this, no? And time is also going to come when the drones will also be questioned. The presence of drones will also be questioned over your house, that they cannot see what is going on in your house. So that is another facet of data privacy. Likewise, when it comes to the fundamental rights, right? Every time, as I just made a mention, if you have listened to my class, my interaction properly, I made a mention of one important thing, that law has to take care of the society, and society is progressively developing. Understood? Society is progressively developing, so law has to change accordingly. Understood? So this may be the case that tomorrow some other aspect of law may be discussed out there, or whatever was held in Indira Sawhney's case or Vishakha versus State of Rajasthan case might have not been upheld also. Right? It might be changed. That scenario can be changed because Supreme Court has this suo motu jurisdiction. It can change its own stuff. That could be done. But before doing so, there has to be a proper mention of the facts concerned, that why the Supreme Court has done that. And even after doing so, you will have the liberty to either accept that sort of stuff or reject that stuff. That is up to you guys.
Right, sir. Superb to just hear to you. It was such a humbling experience for all of us. And I hope the students have gained something from the session as well. Thank you so much, guys. Thank you so much for joining, and hope you are doing justice to your preparation for Common Law Admission Test 2021. We will be organizing a series of practice session on YouTube GSL channel. So make sure that you subscribe to our YouTube channel and make sure that you keep on watching these videos on YouTube as well. Thank you so much, Rahul sir. It was a wonderful experience to hear you.
I'm happy to talk to you, sir. I'm happy to talk to you all. And
Yes,
thank you very much for IMS for this golden opportunity which was given to me.
Absolutely.
And I wish to see you again.
Absolutely.
God willing then, not an issue. I hope all the students are happy and they have gotten many glimpses of what is happening around them.
Absolutely, sir. It's a pleasure always, and I hope to see you again. Thank you everyone for joining. All the best for your Common Law Admission Test. Stay safe, stay happy, stay content with your preparation. That is something that you have to do. And I hope you get into one of the best national law universities, or for that matter, any law entrance, any law university.
One more thing I would like to tell to all the students, sir, one takeaway I would like to give. Friends, you must have seen the interaction in between Arjuna and Lord Krishna in Mahabharata, right? When the battle of Kurukshetra was going on. So at that point of time, Lord Krishna told this to Arjuna, that karmanne vadikaraste ma phaleshu kadachana ma karma phala hetur bhurmate sango sangata karmani. It means pursue your goal with devotion, discipline, hard work, and proper agility and timetable. And you are sure to get what you have been desiring. Thank you so much.
Pleasure, sir. Pleasure. Thank you all. Thank you, sir.